Hey everyone, good morning. I'm JD Houvener, your host of the Bold Today Show. You've made it to our weekly live show where we're publishing and broadcasting on Facebook, Google's YouTube, and Twitch today. I'm excited to have our live viewers and field some live Q&A about anything related to inventions, patents, intellectual property, including copyrights, trademarks, trade secrets. Bring it on. I'm going to be here for up to a half hour, and I'm here every week. So if you missed us this time, you're welcome to come back and check out our Facebook page and look for the link to join next week. So we've got an action-packed day today. I've got a brief disclaimer, as I put down every week. If you're new to the program, just know that we are not going to be an attorney-client relationship here right now. This is a fun public forum that's not going to be some place to put your confidential invention information. So please hold off on that. And if you're excited and you want to move forward, I will be providing a link shortly on how to get a hold of us and schedule a screening session to see if, maybe now is the right time to move forward with your invention. So I will put that link in after I go over the agenda today. I was trying hard to get some guests for today. I don't think we're going to be able to get them. They might pop in by surprise backstage, and if they do, I'll bring them on. So the agenda today, we're going to cover our normal stuff. If you're familiar with this, we're going to go through our success story of the month. I'm going to show you Kevin Yacarino. I'm so pumped about him and his new tool for lifting buckets. I'll show you that. Then we're going to talk about our topic of the day, which is prototyping, right? When to do it, how to prototype, how does that fit in terms of the patent process? And then we'll, of course, take live questions and answers throughout the program. And then we'll go to our avvo.com questions. And I've got 3 patent application questions there to go through. So a lot to get done in a half hour. Again, I'm going to be prioritizing those live questions, so keep those coming. It's good to see you guys out there. Please give us a like if you haven't done so already. Share this on your social pages. I want to get this out to as many inventors as possible and have some fun here. All right. So if you missed the introduction, I'm JD Houvener. I'm a patent attorney and owner here at Bold Patents Law Firm. And I want to provide you a link now if you are ready to move forward with your invention. And at least maybe if you want to see if you're ready. We have what we call our screening session. And I've got the link right here where you can actually do that. Okay. It's linked on my Google Sheet. I'm realizing that the link didn't come through on that link. So there is the link to schedule. And if you take action and schedule, you're going to get a copy of this book right behind me, Bold Ideas, The Inventor's Guide to Patents. This book is a book that I wrote myself, and it covers kind of the basics of what you need to know about patent law, the difference between trademarks, copyrights, and trade secrets, and how the process is and what to expect. We love working with educated, informed inventors that kind of know what they're getting into as we get started. So that's the best way to go, is to do some diligence on your own and get educated. Okay, so our topic of the day is about prototyping. And before I get to that, I want to showcase, and I'm going to share my screen with you to share Kevin, bring in Kevin, who is a client of ours. And he has graciously allowed me to share his profile and his invention with all of you. And we featured this on our newsletter that went out earlier this month. So if you weren't on our newsletter, you should get on it. And here is a PDF of the newsletter that went out. So I'm going to zoom in a little bit. This is part of our Bold Inventor stories, and we send these out every month. We find and decide which story to pick. And this month we chose Kevin. So Kevin is a client. He is now patent pending. Okay, he's got a tool to basically lift 5-gallon buckets, and it's for anything, right? You put in a 5-gallon bucket, whether that's paint, maybe you're moving rocks, landscaping, water, right? Whatever you're trying to do. He wanted to solve this problem of this awkward container, right? This cylinder that can get pretty heavy, and if you're doing a lot of lifting, how do you deal with that? His attorney, Huda Elgera, is one of our longest-standing patent attorneys here at the firm. She helped him with getting this patent application, did the research, drafted the application and the claims, and have now got it sitting before an examiner, hopefully ready to issue within the next year or so. So kudos to you, Huda. Thank you for helping him. So yeah, Kevin's idea is to stop the backbreaking work, and it may be a little hard to see, and I will zoom in a little bit more here. We've got a picture of the patent pending photograph that was submitted. So on a 5-gallon bucket, instead of having to use your hand under the bucket, Kevin has crafted a very interesting, made of metal in this current version, to support the weight of the bucket and provide a handle to hold on to, and it attaches just under here. It's out of sight, but it hooks into the bottom lip of a 5-gallon bucket and provides a really cool ergonomic support. So we featured Kevin in this article. He's got this this concept, and he's going to be starting to do some prototyping. And as I wanted to kind of bring that up, as that's our subject of the day, and how do you get started? Who do you contact? So that is Kevin's story. I will stop sharing. So prototyping, right? And a lot of inventors, entrepreneurs even get hung up a lot with prototyping, and they think, gosh, I have to get a prototype built before I can even start, speaking with a patent attorney. Before I can start even thinking about doing getting rights protected. And what I tell inventors is there's a balance. If your invention, if you're not sure your invention will work, okay, and maybe you're not in the same industry, you don't do this for a living, the invention is sort of outside of your daily norm, then that may be a very good reason, right? You don't need to even know if your idea, your concept will actually work, and you're still not at that, what I call proof of concept phase. So if you need to get to that point, to just prove it to yourself that this invention that you've come up with will work, I agree that a prototype is required, right? Some effort must be made to get to that point to where you're like, yes, this is awesome. This is working the way I want it to. And so if you can do that on your own, great. If you do need to bring someone else in, maybe because of the types of materials that are being used, your background in actually fabricating or getting dirty and getting your hands involved in building something just isn't up to par, then you need to work with a third party. And there are a lot of really good designers, prototypers, and companies, and I was going to hopefully have some of them on today as guests, so we'll have to wait till next week to get them on, and how to do that. So I would say, when possible, you want to try to make sure that when working with third parties, try to keep them geographically as close as possible. Within the same state is great, because you want to make sure that if there is an agreement, which there should be, so that anything you discuss is going to be confidential, it all stays within the same state, okay? And you can enforce something if for some reason, heaven forbid, this third party decides to breach the contract, and let's say, expose your invention or try to monetize or commercialize it on their own, you'll have the ability to, readily within the state enforce that contract under your own state laws. Outside the state, right now, you got to think about different state laws, and then even outside the country, and now you're really risking a little bit, right? If you're talking about having to enforce a contract overseas, let's say in China or Korea or Japan, so any other country, that is very challenging, right? So you want to be careful at who you're working with and helping get a prototype started. So if you are past that phase, if you're certain that even if you can't actually build it, you don't want to put the money down to build this invention, but either through your own experience or just through your own, economical structural knowledge that this is going to be workable, you could actually build it, you can and should move forward to the patent process to try to secure protection. And as I go through in a lot of my other, presentations and online YouTube videos, I highly recommend hiring a professional to do a patentability search and give you an opinion on, hey, should I even file? So before you rush and just file something, get that search done to do it right. But don't stop just because you haven't built it yet. In some cases, if you're able to describe it in words and through pictures, you have got an invention, and you've got enough for us to be able to do a very good search and provide a great platform to write a solid patent application. All right, so that's my little spiel on prototypes. I welcome your questions if you have them. I do want to provide a link here to get a copy of our free book, okay? And this is the book I got right behind me. So take a look at that link right above. Is a free session to discuss what your invention is about with one of our non-attorney advisors. They will sort of help you understand and kind of think through whether the timing is right to hire a patent attorney. And if it is, then they will schedule you with either myself, Tom, or Matt, one of our trademark attorneys, to see if we can really get down and dirty and understand your invention at a very detailed level, and then give you an opinion on eligibility from there. All right. So no live questions just yet. I did see we have 3 live viewers, so it's good to see you all out there. And thank you for that like, by the way. Okay, let's jump to our avo.com questions. I have got 3 of those. So let me copy and paste this question in. Because when I share a screen, it can get lost a little bit. So I'll put just the first part of this question up there. And we'll go from there. Okay, so there it is, and I'll show it. So it's a question about patent application. How much is the fee for extending the reply within the 3rd month if you already paid the fee for extending the reply on the 2nd? Very good. Yeah, so someone in this scenario has already submitted their non-provisional patent application. They have received an office action, which is where an examiner looked at their claims and what they submitted in their written description, and they said, you know what, sorry, I'm going to reject this, right? For novelty, for non-obviousness, some objection to the drawings, right? For some reason. And there's been an office action response that this individual is working on. And so the question is, in that response, you usually have within 3 months to respond without paying any type of extension fee. And you can pay additional extension fees all the way up to 6 months. And this individual is now talking about the 3rd and final month. And that's the last chance to be able to reply to this examiner. And with this examiner that hasn't yet responded, you have to pay fees. And so up to the 3rd month, there's additional fees. So I'm going to pull up the fee schedule on the USPTO. And for any of you out there, just to see, we had one of our design experts come on. He's backstage. Hopefully we'll bring him on when I get done with this question here. So let me share a screen. All right. There we go. Okay, so the USPTO.gov fee schedule. Okay, and I know it's maybe kind of small for some of you on the screen, but you can see extension of time fees. So if you're within the 1st month, you're going to pay $200. 2nd month, $600. 3rd response, you're talking over $1,000. Now there are ways to reduce the fees if you are an individual inventor or you're part of a small company. The fees can actually be greatly reduced. We're talking down to $50, $150, or $350. So those are the fees you'll pay depending on how long you're extending. And so depending on the kind of office action, you can extend up to 5 months. So those are the fees right there. So I will stop sharing, and I will bring on our guest here. I want to introduce Andrew Lees. Andrew, welcome to the show.
Hey JD, how's it going, man? Great to be on.
Absolutely. I know I just asked you this morning if you could make it, so thank you for coming.
Yeah, happy to be on here. Sorry I'm a little bit late. I just saw your email is going through, and I'm like, oh man, I got to get on there. And
awesome.
Glad I didn't miss it.
Yeah, good deal. Well, we got we had a little bit of a group here, 1 live viewer right now, but this is a broadcast that goes out weekly, and I call it the Bold Today Show. And the topic today, which I had in mind for you, was sort of this how, when, and where to prototype. And I had a brief discussion before you hopped on, where I was kind of talking about, some inventors, entrepreneurs, they get sort of stuck in this bind where they don't know what should go first in terms of moving forward with patent protection or building their product. And my pitch was, hey, look, if you need to prove to yourself whether something works or not, you're at that proof of concept phase, you got to go build it first before talking with the patent attorney and make sure it can work. What are some suggestions, things you talk about with inventors that are just getting started and kind of nervous about prototyping?
Yeah, it's a great question, because I think there is a lot of question from a lot of people about how to do this, how to approach it. I think a lot of inventors and startups are kind of thinking, hey, the first thing I need to do is patent it. They think of patent, and they think maybe of manufacturing, but they're not really sure what to do there yet. So they'll go to somebody like you, which is great. But then they're not really sure when they should actually start developing their product. So I would always say sooner the better. The more you can do to develop your product, the sooner the better, because that's going to help you, as a patent attorney, that's going to help you write stronger claims. I think, the more that you have figured out, the more you can really protect. So if you can at least get a concept level design figured out from a product development firm, then that's at least like the first step, I think. So you start that, I would say get started with a patent search. Then I would say kind of at the same time, I would really recommend working with a patent attorney and a product development firm at the same time, because they're going to be talking to each other, just like, you and I talk, and your patent attorneys at Bold, who are all awesome to work with. It's a great experience, and I can inform them about how we're doing with the design. They can let me know what comes back with the patent search and where they are with the patent. And you guys are going to write great claims. It's going to help me develop a better product. So I think the more you can do, the sooner the better. Some clients are like, hey, I'm going to go full tilt and develop the full detailed manufacturing level design first. And that's great. I mean, that does take some time, so it's good to get that process started.
Totally. Yeah. Thank you, Andrew. This is awesome. Yeah. I mean, it's a perfect synergy, and working with a product development firm like Stoke Ventures. It's sort of people get nervous. I think that they're like, oh, I have to have my idea perfect, right? Totally thought out, and it's so nice and refreshing to know that it's actually quite common and recommended to get a third-party design team to look at what your idea, your concept is very early. And you're exactly right. I want to underscore the fact that if we bring a new client on and they've got not just back the napkin sketches, but they have something that's well thought out with some detail, it helps us do an even better job searching and even better job drafting the application to cover really broad applications, different versions, right? Instead of being so myopic on, hey, what do we think we can go to market with? It helps us think about outside the box and help protect them really broadly.
Yeah,
so
absolutely.
It's a good point. Yep. Awesome. Well, good. And so in terms of actually getting started, and you mentioned the sort of concept development, just the first baby step. How does that look? If someone were to work with you at Stoke Ventures, what kind of project scope, what could they expect to get out of that initial meeting? Hey, I got an idea to get me to the point to where I can start feeling like I've got something to hold on to, whether it's digital or real.
Yeah, exactly. And it is a little bit weird because you're not getting something physical. You're not getting a prototype, but even with even if you follow through with the detail design, you still obviously, even with that, you have CAD models, you have a detailed virtual representation of your product, but until you actually then pay to have prototypes made, you don't actually have anything physical besides those specs. But so with the concept level, you're getting a virtual representation of your product, but it's not detailed out. It's more, I'll say this. So it's more than a pretty picture because there's a lot of invent help type companies out there, that'll kind of take advantage. They'll charge a lot of money for just a nice picture. There's no detail, and really there's not a whole lot you can do with that. But it, so they're kind of charging like what it should cost for a detailed level design, but they're only giving you the concept. Right. And maybe not even a great concept. So what you get with the concept is really a representation that's not detailed. You can't manufacture with it, but you can definitely present it. You can communicate it. You can use it in a patent application, which is really helpful. And you could present it to investors. You can also, what we'll do, a couple of things is, because we're actually creating real CAD models with those non-detailed models. We're just not spending all the time and all the cost of going through all the details. So, but we still have a CAD model that we can then use to make the detailed models. So like if you're working with an Invent Help company and they give you a pretty picture, a product development firm they basically have to start from scratch. But what we would be doing is creating actual real 3D CAD models that represent the product that can be used for demonstration and for the patent. And then that cost is like an investment in the total project. So, so you're not starting from scratch. We can use those models to then you put the details on.
Cool. Yeah, and some people are worried, am I ready to even talk with someone like you, Andrew? If someone comes in and they just literally have the idea in their head, is that enough to get started, or do they need to have something else done? How early could they talk to you?
Right from the beginning. So as soon as you have an idea, you really don't have to have much. I talk with some people who are like, oh man, they want to send me a sketch, but they're worried about their sketching skills, and they're like, oh, it's not going to be that good. And no problem. I mean, really, I can work with anything from a napkin sketch. I've seen some really, really bad sketches. And honestly, I'm not an amazing artist myself, by any means. I'm really, what I do is I get those ideas and I compile them, and I, wrap my brain around them and figure out how we can, as quickly as possible, get them into CAD models that we can start to do something with. So, but as soon as you've got an idea, it makes a lot of sense to get that patent search started with you and start working on a design.
Awesome. Well, Andrew, I really appreciate you coming out. This has been great. I'm going to encourage anybody that's watching this after the fact to get a hold of you. What's the best way to do that? Website, email, what do you prefer?
You can go to the website, stokeventures.com, and you can just schedule a call right through there. And you can also reach out to me directly at andrew@stokeventures.com. Okay,
I'll put the URL right there in the chat.
Yeah, scheduling a call is the most efficient way, because I'll get that, and then we'll talk whenever you can.
Awesome. Andrew, good to see you. Good to chat as always.
You too,
we'll
JD.
Put you backstage. I'll be on for another 2-3 minutes. I'll wrap up the AVO questions, and we'll have you on in a future session. So
awesome.
Take care.
Yeah, I'd love it. Thanks, JD.
All right. Cool stuff. Well, probably just time for one more question from our AVO group. So thanks for being patient there. That was awesome to get Andrew in. So there was that patent extension question. I've got this one called, should I get a patent? Okay. And I'll put the full question here on the screen. All right. Should I get a patent? I've got an idea for a drill accessory, and I guess it would make sense to take ownership of it before I make it and sell it. I love it, and there's no question too simple. So please bring it on, everybody. I know some people are worried about, oh my gosh, it's a patent attorney. I've got to make it a really good question. Anything goes, right? So someone's got an idea for a drill accessory. Cool. I don't know is the answer, right? I will help you find out. And so depending on what you've come up with for this drill accessory, for it to be patentable, it's the big 3 criteria. It's got to be new. Okay, not just in the country, but in the whole world and of all time. Okay, so good luck with that. So it's got to be brand new, and it can't be an obvious version of some other drill accessory that is already published or being sold or on the market or patented before. So those are the 2 big hurdles to clear. And of course, there also has to be functionality and a utility, a benefit to the accessory. So I would need to see it, of course. There are some eligibility concerns. So sometimes these come up, and I want to make sure I let people know now, if you have shown your drill accessory or published it online, say in a YouTube video or launched a website, Kickstarter, those sort of things, more than a year ago, unfortunately, it's not eligible for patent filing. So hopefully we've caught you before you've published or sold this drill accessory, and it's been less than a year, you can still seek patent protection in the US. There's a nice 1-year grace period for that. I personally use a lot of drills. I know there are a ton of them sold. And I'm just looking at like Home Depot or Lowe's, they're just aisle is full of the electronic battery powered wireless and even, powered drills. Any type of an accessory that could help make those more functional, I think it's a winner. So I think it's a great market to be in, just at a sort of a gut level. So before you go file a patent, hire a patent attorney to help you think about filing or getting a patent search done. If you're having trouble coming up with how to portray how the actual accessory might look, and you're not able to even tell your attorney what it looks like and what sort of functionality it might have, get hold of someone like Andrew Lees at Stoke Ventures to help you really put that idea, get some meat on the bones, so we can do some good work and help you perhaps speak with those in the market to help move it forward. So thanks for that question. Okay, one last question coming up. This one is also patent related. This is out of Jackson, Tennessee. And I'll put the question here. Again, I don't pre-screen these, so some of these might be kind of funny, but I love them because they're raw, real questions. Almost as good as live questions. So if you're watching at the back, please join us live next week if you're not live now. So here's the question. Looks like it's going to be a two-parter. I need a patent and need a patent attorney, but can't afford one. What are my options? Okay. I have a great invention that's simple to make, but is very useful, but I'm broke. I have a homemade prototype. I love it. What can I do to get funded for a patent attorney without money to get a patent? Okay. There are options. I mean, what I tell inventors that are hard in their luck, don't have much money, is you should always start with friends and family. Okay, friends and family, there are an enormous amount of resources. Sometimes if you've got a compelling enough story, if you believe in enough what you've come up with, you can find a way to get the money in almost every case. Enough to where you can do enough diligence, right? Hire an attorney, a patent firm like ours to do that research, at least that much to confirm that you've got enough to move forward with, that you've got a patentable invention, and an attorney that signs off saying, yes, this is patentable, you should file. And that opinion you can take literally to the bank in many cases. I've had a couple stories of inventors that take our opinions to the SBA, right, Small Business Association, and can actually secure a loan in some part relying on that opinion. Certainly, you could use that opinion to approach third parties, right? Third-party investors, angel investors, seed investors. They're out there. People are out there that have money, don't have good ideas in many cases. They're looking for good ideas. So you have that idea. You guys just need to connect. I kind of point out some of the obvious, but LinkedIn, Facebook, when COVID ends, right? In-person gatherings, meet and greets. This is where the hustle happens, right? You go meet and network and make it happen. So, and it's not an easy answer, right? But if you've got a good invention and a good enough motivation to get there, you can find a way to get the money. All right. Well, I'll bring Andrew back on to look if there are any live questions. But Andrew, thanks again for hopping on, being a part of that journey. 1 minute left. Do you have anything to add to that last question that I answered?
I think that was great, because I think that's a common question for me too, is I just don't have the funds to start product development. I definitely understand that. But there's always a way to do it. Friends and family, you can get money that way. Some people feel really uncomfortable with that, and I totally get that. But I love your solution about getting your opinion letter and taking it literally to the bank and getting a loan. Even I wouldn't recommend getting a big loan to start a business, but something that you're confident you could pay off if nothing ever happened, because there's some risk there, but just to kind of get you started. I love that idea. And there's always a way to go from zero to making it work. And I would also recommend that getting customers is really the hardest part of business, right? So patents, one thing, the Product development is one thing. But then once you have all that, you've really got to get customers. And so I would start with connecting with people as soon as you can, and start to, if you can, start to build an audience on social media, maybe a YouTube channel with a blog. Start to build an audience around what your product is going to be. And you don't have to divulge any information about your product. Just create a following, and that's gold. You can sell your product. You can be an affiliate. You can sell other products. It's a great way to make some money. Not going to get rich on ads, so don't think that. But I would always recommend that. Yep.
Well, you sound like you've got some expertise in marketing too, not just prototyping. Is that right?
Right.
Yeah. Cool.
Yeah.
Excellent. Well, we're at our time limit, Andrew. Thank you again for coming on. And for all those that are wondering what prototypes are all about, how to get started with design or even marketing, get a hold of Andrew. And again, book that consult with our advisors to get started. So without further ado, I'll let you guys go. I'm JD Houvener, CEO, patent attorney at Bold Patents Law Firm. Go big, go bold.